you deal with creditors after a bankruptcy discharge. As many of us know, filing for bankruptcy is a difficult decision. The process can be stressful. The after effects can be stressful. They don't have to be always, but sometimes they are. And you deserve the fresh start that a bankruptcy discharge provides. Unfortunately, some creditors and debt collectors may ignore the discharge and continue to harass you about debts that you no longer owe. This is wrong and can cause significant emotional distress. So know your rights. The good news is that you have legal options to fight back. If a creditor was included in your bankruptcy case and was properly notified, any attempts to collect a discharge debt are likely legal. You don't necessarily have to meet all those requirements, but it's great if you do. Ideally, the best case scenario, you can show that the company contacting you is the legitimate creditor who was part of the bankruptcy. This would be like if you got a Synchrony account or something of that nature, but that particular account, and Synchrony was notified they were part of the bankruptcy. It was filed in the petition and the exhibits, and you are getting contacted by Synchrony for that same account. That is awesome. No real question there regarding that. Also, that the creditor was officially notified of your bankruptcy proceedings. If Synchrony Bank was included, they're going to be officially notified of your bankruptcy proceedings because they're going to get the petition. They're going to get all the filings probably, assuming they ask for them. But they're going to get notice of them officially from the bankruptcy court. And the creditor that's contacting you ideally about the discharge debt they're contacting you rather after the debt was discharged and the discharge was finalized. That is for a creditor, that's ideal. Those are the three elements you really like to see. You don't have to have all of those. There's something called an automatic stay. So if they're contacting you after you file a bankruptcy petition and they haven't asked for relief from the stay, there's a problem there. Creditors, we handle those differently depending on whether or not there's been a discharge finalized yet. But a debt collector, that's an FDCPA violation straight out of the gate. As far as being officially notified of the bankruptcy proceedings, they don't necessarily have to be officially notified through the bankruptcy court. It's nice if they are, but many times we can show that they knew about the bankruptcy. They pulled your credit report and it was on there. I can tell you that most creditors, in particular, get notified of your bankruptcy proceedings long before they get a letter in the mail from the bankruptcy court. There's electronic reporting. They know before your bankruptcy attorney knows that your bankruptcy petition's been filed or been accepted by the court. And they don't have to be the original creditor. So if you get a Synchrony account, this happens quite a bit. Synchrony, you file bankruptcy on a Synchrony account, they immediately sell that debt sometimes to Midland Fund or Portfolio Recovery Associates. So it doesn't have to be Synchrony Bank. It could be someone who's down the line. We do probably have to show they knew something about the bankruptcy case, but that's almost always known by them. So that's not a big deal. So, those three aren't hard and fast, but they're really great if they are. And if you meet any of those conditions or anything close to it, you should talk to an FDCPA attorney. We can force the creditors to cease communication with you regarding the debt. Court can force them to do it. And hopefully this will result in some compensation for damages, but potentially including emotional distress, as well as any out-of-pocket expenses that were incurred due to harassment. And additionally, it's probably the best part for making these cases useful and viable is that the attorneys are allowed to do this on a contingency fee basis. So you don't have to pay any upfront fees. If the case is big enough, they take a percentage like a car wreck case, or if it's a FDCPA case where the damages might be lower, but there's a fee shifting provision. So the debt collector or the creditor has to pay your attorney's fees and costs. So don't suffer in silence. If creditors are asking you about a discharge debt, or a debt that's including your bankruptcy and you just haven't got the discharge yet, but they've gotten notice of the automatic stay, attorney can help you. Give someone a call. We're happy to help if we can help, either because of this or some other consumer law issue. Cliff Carlson Law, give us a call.